Hey everyone, this is Edward, and today we're going to discuss the case Hawkins versus McGee. And we're just going to cover the items that are necessary for the law school exam. And I just want to say this about law school. Law school is a lot of fun, but they do play hide the ball. So, and also the textbooks here, they all play hide the ball. So you can spend hours there trying to find the issue and the rule and the elements. But here, I'm gonna just give those to you right away so you'll know what you are discussing. And let's go ahead and get started. So let's skip the introduction here. I'm gonna align my speech with this text. So let's go to the section 1 here. That's the case. Now, you do want to know the procedural standing. Usually there are 4 parts here. There's a trial court level, the appellate court, state Supreme Court, and the U.S. Supreme Court. And here we're talking about a state Supreme Court. Now, you are going to need this as well when you take the bar exam. As in fact, the subject of contracts is tested in many states. So you do want to hold on to these notes that you make. And of course, many state bar exams also have what's called the MPT, the multi-state performance test. And there you do have to discuss cases, and you do want to know the procedural standing. So just get used to that. It's something handy that's gonna be useful down the line. Now let's get right down to section 2. What does this case have to do with the law school exam? Let's get right down to it. So you have the issue, what is an issue made of? You have the rules, and one of the elements there is that the facts must show that a party does have a manifestation of an intent to enter into a contract. So this is like the big picture. This is what you want to remember for your law school exam. You won't need this. You will need this. But we'll be more specific as we go down these, discuss these subjects, these sections. So let's go ahead and go to section number 3, main headings. Now, contracts. Now, what I say about contracts is this, that it is a subject that is very organized. It's one of the most organized subjects in law school. But it's one of the subjects that is presented in a very unorganized manner. It's probably the subject that is presented the most in the most disorganized fashion. So you have both extremes there. It's very organized, but it's presented in an unorganized manner. But let's talk about that, okay? Because when you take the exam for contracts, you will have to discuss many of these main headings. Applicable law, are you under the common law or the Uniform Commercial Code? Right now, this is the first case we're discussing. This might not mean a whole lot, but just keep it in mind because we are going to see it again. And then, of course, the contract formation stage and defenses to formation. Again, these headings might not mean very much at this point, but we are going to get to it. In fact, today we're going to focus on one of these. So let's see what we are talking about. So again, this is the big picture. So Hawkins, this case, what is it discussing? Here we go. Categorized under the main headings. We're going to talk about the offer. Now notice that the book does not start with the applicable law. It just goes into the contract stage. Again, law school, and these texts, they're meant in many ways to confuse you, to intimidate you, but as long as you get a good grasp of this, you'll be fine. You will excel. So we are going to talk about the offer. Again, this element that we discussed earlier. Let's move on. Keynotes from this case. So we are going to base this edition of this particular book on the Farnsworth Edition textbook, which many schools do have, and if that changes, then we'll go ahead and make a change as well. Important question that this case deals with: when does the statement become a promise sufficient to satisfy a manifestation of intent? So that translates to this: when do words become legally binding? That's another way of looking at it. An important question again. This case deals with damages. Now, Farnsworth says, hey, look, we're going to discuss damages later because actually that comes under, it's another topic here, remedies. But Farnsworth is saying, hey, look, we'll touch that later, and we are going to discuss that later. It will be very important. But for the purpose of this particular segment, we're going to just go with the Farnsworth Edition. And we're also going to discuss remedies and damages in another version of this. So let's go ahead and talk about some notes here. So what the defendant is saying, he's saying, look, there was no intent, because if there is no intent, and then there cannot be an offer. And if there is no offer, of course, there is no contract. And you can read some of the words here that the defendant argues. We're not going to go into that, because again, we're just touching on what's important for the law school exam. But if you want to purchase this particular text, there's a link here at the bottom. And let's see, some of the factors that they consider in the case is the language. And what does Dr. McGee says? He says, I will guarantee to make the hand, okay, perfect. So he does make a statement. And of course, the context, what's going on in the context. So let's talk about the context here. So the court is going to take this into consideration. It's going to use it as a factor. So in this case, the defendant, who was a doctor, he did make offers to the plaintiff. He said, hey, look, let me perform. And also the defendant was eager to experiment in an area where he had little experience. So again, these are factors that the court did in fact look at. And restatement and codification. So you are going to come across this, the restatement, section 2. And here's what it says. It says the promise is a manifestation of an intention to act or refrain from acting in a specified way. So I don't want to sound like I'm just doing the blah blah thing. But what you want to take away is this word here, intention. So McGee contributes to the formation of this particular restatement. So that's one word you want to take away. And as far as the other words here, the other elements, we'll get to that in another section. We'll say that for another day. Let's go for the holding for law school discussion, and again focus on the word intent. And this one is going to be, this particular statement is going to be a little lengthy, because in your discussions in law school they might discuss this. So it's just something you want to keep in mind. But again, here we're talking about the exam. So we're not gonna get into this, but again, if you look closely, you do see the word intention there. All right, everybody see that? You see how everything just kind of handed to you? There's no hide the ball here. The analysis, again, the analysis is something different. So you have to know that there's the issue, there's the rule. Okay, the IRAC there. The analysis is something different. It involves different parts of your mental capacities. So you have the issue, you have the rule. When you analyze, that's a skill. And I do want to say this, that most law schools do not focus on the analysis part. They focus a lot on the issue and rule. That is particularly certain for law school discussion. So just keep that in mind. And we're going to get to analysis again at another time here. Now, holding it for exam purposes and the takeaway. Now, this right here, this statement is more narrow than this one that was previously mentioned. This one is more lengthy, it has more words, but this one is more narrow and it's more specific. And it says an intent to form a contract was found when these factors were met. Again, you have the word intent and the factors, and we already mentioned these. The defendant repeatedly solicited from the plaintiff the opportunity to perform. And of course, the doctor there wanted to make some experiments. So again, the key word there is intent. And these are just factors. Keep that in mind. And let's see. Again, the commentary just says that you want to get to the point where you can develop a holding and use one sentence to summarize the case. And the holding here for the exam, it does have the issue, it has the rule, it has the analysis, and it does have the conclusion. When you get to the bar exam, you're definitely going to have to know how to do a holding for one case. And again, that's down the line as well for many of you guys. So just keep that in mind, that at the most, use 2 sentences. Now here, what I did was I stated a sentence: an intention to form a contract was found when these factors were met. So I do use a colon there, and that just gives me space to just put this on in one sentence. But At the most, I would use 2 sentences. Now, here's a good thing here that you would definitely want to set aside and put this somewhere where it's going to build up, somewhere safe, because you are going to need this language when you go to the bar, when you take your law school exam. And I keep saying the bar because the contract is, again, it's one of those subjects that is tested at many state bars. And here's the wording. Is there an offer present? An offer requires a manifestation of an intent to enter into a contract, and you are going to need to discuss that, and that's the end of this section. Now, section 8. Okay, this is the last part, and there's a free ebook here that you want to download. It's very thorough on the, it has the main parts that you need to know for the exam. So do make this a part of your study materials. So I hope this helped, and I wish you the best, all the best in your exams. Until soon.